The New York Times versus Sullivan. Slide 1. Who are the parties of the case and what are the facts that led to their dispute? The plaintiff, slide 1. The plaintiff of the case, the New York Times versus Sullivan, was a public official from Montgomery, Alabama, who brought this case of defamation because he felt he had been libeled in an advertisement by the defendant's newspaper, the New York Times, in which the text appeared over 4 names of the petitioners. Slide 2. Why did Sullivan feel his reputation was damaged by the New York Times publication? In the advertisement, statements were included, some of which were false, about the police action. It alleged that police actions were directed against students who participated in a civil rights demonstration and against a leader of the civil rights movement. Sullivan said the statements were about him because he was a supervisor of the police department, entitled Their Rising Voices. The advertisement began by stating that as the whole world knows by now, thousands of Southern Negro students are engaged in a widespread nonviolent demonstration in positive affirmation of the right to live in human dignity as guaranteed by the U.S. Constitution and the Bill of Rights. It went on to charge that in their efforts to uphold these guarantees, they are being met by an unprecedented wave of terror by those who would deny and negate that document, which the whole world looks upon as settling as a pattern for modern freedom. Slide 3. What must the plaintiff show to prove defamation, in this case libel? To prove defamation, in this case libel, the plaintiff must prove that the defendant printed false statements with malice intent to harm his reputation. The trial judge instructed the jury that such statements were libelous per se, legal injury being implied without proof of actual damages, and for the purpose of compensatory damages, malice was presumed, so that such damages could be awarded against petitioners if the statements were found that had been published by them and have been related to the respondent. As to punitive damages, the judge instructed that mere negligence was not evidence of actual malice and would not justify an award of punitive damages. Number 4, slide 4. What was the Supreme Court's decision and why did it make this decision? We think the evidence was constitutionally defective in another respect. It was incapable of supporting the jury's finding that alleged libelous statements were made of a concerning respondent. Respondent relies on the words of the advertisement and testimony of 6 witnesses to establish a connection between it and himself. The court reaffirmed the statement in an early opinion that there was no legal measure of damages in the case of his character, ID, at 686, 144, so, period, 2D, at 50. It rejected petitioners' constitutional contentions that the brief statements that the First Amendment of the Constitution did not protect libelous publications, and the Fourth Amendment is directed against state action and no private action. The evidence was constitutionally insufficient to support the judgment for the respondent, since it failed to support a finding that the statements were made with actual malice or that they related to the respondent, pages 285 to 292. The judge refused to instruct that actual intent to harm had been found before punitive damages could be awarded, or that the verdict for the respondent should differentiate between compensatory and punitive damages. The jury found the respondent and the state Supreme Court affirmed. A state cannot, under the First and 14th Amendment, award damages to a public official for defamatory falsehood relating to his official conduct unless it proves actual malice. Of the Supreme Court. The Supreme Court of the United States holds that the Constitution delimits a state's power to award damages for libel in actions brought by public officials against critics of their official conduct. In this case, the ruling requires proof of actual malice is applicable. Gertz versus Welch. Part 2. Slide number 5. Who are the parties of the case? Is the petitioner a private person or a public figure? A magazine, American Opinion, attacked the reputation of an attorney, Mr. Gertz, by publishing false accusations and attacks of his character. Mr. Gertz is a private citizen and is not beholden to the same rules of defamation of a public official. Slide number 6. What were the alleged defamatory statements about Mr. Gertz in the American Opinion article? The respondent ran an article which accused Mr. Gertz, the petitioner, of being the architect of a frame-up, a Leninist, and a communist fronter for bringing a suit against a local police officer who killed a child. And in the article, the respondent implied that the petitioner had a criminal record, but he made no effort to verify any of the statements published. Slide number 7. What was done to confirm the accuracy? Slide number 7. What was done to confirm the accuracy of these allegations against Mr. Gertz? The managing editor of American Opinion made no effort to verify or substantiate the charges against the petitioner. Instead, he appended an editorial introduction stating that the author had conducted extensive research into the Richard Nuccio case, and he included in the article a photograph of the petitioner and wrote a caption that appeared under it: Elmer Gertz of Red Gill harasses Nuccio. Respondent placed the issue of American Opinion containing the article on sale at newsstands throughout the country and distributed reprints of the article on the streets of Chicago. Slide number 8. How do you think these allegations affected Mr. Gertz's reputation? I think these allegations caused great harm to Mr. Gertz's reputation. He was being called a communist and a defender of someone who had killed a child. Such accusations are no good to the reputation. Slide number 9. What would you have done differently than Welch to avoid lawsuit? I would not have printed the accusations without first verifying their truth. I know the primary goal is to sell magazines, and I would have come up with another angle for the story, or I would have found a candidate who fit the accusations. I would have had my legal department go over the article and not assume I would win in a legal battle because of the ruling in the New York Times versus Sullivan, in which the New York Times won. Slide number 10. What is your state defamation law? New Jersey's defamation law. Elements of defamation. In New Jersey, the elements of a defamation claim are: number 1, a false statement about the plaintiff; number 2, communication of the statement to a third party. Number 3, fault of the defendant amounting to at least to negligence. And number 4, damages suffered by the plaintiffs. New Jersey follows the U.S. Supreme Court decision of Rosenblatt versus Bayer in determining who is a public official for the purposes of defamation law. Excuse me. Under this test, the public official designation applies to those among the hierarchy of government employees who have or appear to the public to have substantial responsibility for control over the conduct of government affairs. Costello versus Ocean County Observer, quoting Bayer, reading this text expansively, New Jersey courts have consistently held that the police officers are public officials. Other examples of public officials include a former school district athletic director, a tax assessor, building inspector, an incumbent mayor. Actual malice and negligence. When a private figure plaintiff sues for defamation over statements of purely private concern, i.e., not related to a matter of legitimate public concern, New Jersey courts require the plaintiff to show that the defendant was at least negligent. In cases involving matters of legitimate public concern, the plaintiff must prove that the defendant acted with actual malice, i.e., knowing that the statements were false and reckless disregarding their falsity. Public officials, all-purpose public figures, and limited-purpose public figures also must prove actual malice. Privileges and defenses. New Jersey courts recognize a number of privileges and defenses in the context of defamation actions, including the substantial truth and fair report privilege, and the opinion and fair comment privileges. In addition, New Jersey statutes recognize a privilege for a cable television broadcaster who, complying with their obligations under any state or federal law, regulations, and policies requiring the broadcast services be made available to members of the public. Also, an important provision under Section 230 of the Communications Decency Act that may protect you if a third party, not you or an employee or someone acting under your direction, posts something on your blog or website that is defamatory. We cover this protection in more detail in the section of publishing the statements and content of others. Slide number 10. Number 11. How can you relate what you learned from the Sullivan and Gertz cases to your future work in the communication industry? I will make sure I know if the person I am writing about is a public or private person. I also will make sure I know how the laws of defamation applies. I will avoid lawsuits by writing only factual items that are verified by me personally. I know that with the 24-hour newsroom deadlines, this will be taxing, but absolutely necessary.